In its zeal to make mountains out of molehills, the majority is questioning the conviction of former Alabama Governor Don Siegelman, who was found guilty beyond a reasonable doubt of bribery, mail fraud, and conspiracy by a jury and sentenced to 7 years in prison. The Judiciary Committee staff questioned Simpson for hours about her allegations. Her credibility was shredded beyond repair. Her statements during the interview were misleading and unbelievable. In my view, the committee should consider referring her to the Justice Department for further examination.
The very able ranking member is a good friend of mine, Mr. Forbes. I was surprised by an assertion that he made during his opening statement regarding Jill Simpson, one of the witnesses in the Siegelman case. My friend, Mr. Forbes, at one point suggested that Ms. Simpson's testimony had been conclusively debunked, as he put it, and he amazed me by somehow suggesting that the committee should refer her for prosecution. One point that I hope my friend from Virginia will take note of, and I would ask unanimous consent to introduce Exhibit 4 to the Simpson deposition into the record. Exhibit 4 to the Simpson deposition is a list of wireless phone calls made from her phone. If you examine the phone lists on November 18th, 2002, the date that she contends that she made a phone call to Rob Riley and others, there's a number listed, 205-870-9866, 1118, duration for 11 minutes. All three affidavits submitted from Mr. Butts, Mr. Lemke, and Mr. Riley deny that there was a conference call that occurred on November 18th. Mr. Forbes, in light of that revelation that these three affidavits are contradicted by the phone record, I ask you to withdraw your statement, sir, regarding possible perjury by Ms. Simpson.
Yeah, Mr. Chairman, if the gentleman would listen to my statement, I didn't say perjury. I said it referred to the Department of Justice for investigation.
I thought it was extraordinary, Mr. Forbes, and given that the records or your statement is contradicted by the phone record.
The gentleman's time has expired.
Mr. Jones, you mentioned your representation as Don Siegelman's attorney in connection with the matters that eventually led to his indictment. I want to focus you on one time frame. I want to focus you on the end of 2004, at least the last 6 months of 2004. During the period of time when you were in communication with Mr. Fega and Mr. Franklin, did there come a point when they made representations to you regarding the quality of their case against Mr. Siegelman?
Yes, that was in July of 2000.
Would you quickly tell the committee about that conversation?
Essentially, we were told that all of the allegations that we had been looking at previously had been written off. They were too trivial to bring with a former government.
Let me slow you down. This is important. The people who made the representation to you that most of the allegations against Don Siegelman had been written off were the two prosecutors, Mr. Fega and Mr. Franklin. Is that right?
That's correct.
What was your state of mind in July, early summer of 2004, regarding the likelihood of the U.S. Attorney's Office bringing a case against Don Siegelman?
All three of us, all three of the defense lawyers felt like that case was coming to a close within the next
And was
month.
that based on statements or your reading from statements that the prosecutors, Mr. Franklin and Mr. Fega, made to you?
It was based on those statements. It was based on my 20-something years of experience, and it was based on our own investigation.
Did there come a point at the end of 2004 when Mr. Fega indicated to you that he had been in communications with the Department of Justice regarding this case?
That's correct. In late November 2004, early December, Mr. Fega apologized for not giving us the answer he had promised earlier, but indicated there had been a meeting in Washington and that lawyers in Washington had asked him to go back and look at the case, review the case top to bottom.
As you move into the 2005 calendar year, did there seem to be a change in the tenor and the tone of the investigation that you noted?
180 degrees opposite.
Would you tell us about it?
It was every month with the grand jury, we saw new witnesses coming forward. Everything was back off the table. The federal role was, I think, greater. It was very public, and it was very intense. It was not a review, literally as review. It was as if the case started all over again. There were allegations that had surfaced that had been written off. But now all of a sudden, with this much wider net that we were seeing that included every financial contributor, every investment that Don Siegelman had made, every check that his wife had written. This was, my public statements reflected that this was an investigation about an individual, and that is just something that we cannot tolerate in this country, to investigate individuals. It does give prosecutors and investigators as well licenses to change, to twist, to cajole testimony.